On today's episode of Whack-a-Doodle,
I've always dreamed about increasing shareholder value
with instructions to spend whatever it takes to defend the company. A cesspool of bigot is that you cannot win because you will spend more litigating than we're fighting over. What do you mean you have a Yale law degree and you're screaming in the courtroom? You shouldn't do that. Welcome to Whack-a-Doodle. Today we'll be continuing on our journey down the rabbit hole of these weird and wild cases. A quick refresher from last week, we investigated the case of Duzick versus Dragon Curve, a seemingly simple non-payment of wages and retaliation case that unveiled some strange behavior from the likely owners of the company. However, my attention was drawn away from the mysteries of fintech by a bombshell revelation dropped by the defense lawyer at the end of the trial that led to shouts of slurs ringing throughout the courtroom. It also is now leading us to dive into a different case involving some of the same parties. In this episode, we are going to focus on some cases that involve Michelle Page, who is probably the co-owner of the companies we talked about last week, and then also her husband, Christopher Page. He was her lawyer at the trial, also lawyer of one of the companies, but maybe not technically a real lawyer anymore. Regardless, it's the two of them. Two of them against the world. So we're going to focus just on one of the cases today. This is what I am affectionately calling the case, though I'm not going to call it that on this podcast because it's annoying to beep out the word every time. The official name of this case is Page Capital Management versus Lerner Master Fund, and it's going to take us back to the year 2006, which is now 20 years ago. I am old. Chapter 1. Seeds and Gates. So as I said, this is the year 2006. Michelle Page decided to quit her job managing hedge funds at a bigger company, and she decided to strike out on her own, and she started her own hedge fund investing company called Page Capital Management. It's also called Page Opportunity Partners, Page Opportunity Master Fund, and Page GP. There are all these different companies, evidently because some of them have onshore and some of them have offshore funds. So the main benefit of offshore funds are that you don't have to pay taxes, but often people do sketchy things with them, but not always. So Christopher Page, her husband, he also worked for the company and worked with her. He was listed as general counsel, chief operating officer, bookkeeper, analyst, compliance officer, etc. And Michelle Page's sister also worked with them. It seems like it was just the three of them running this hedge fund. So unfortunately, I know and care about hedge funds just as much as I know and care about fintech. But essentially, from my understanding, they take rich people's extra money and invest it. And they try to make better investments and make more money than if they just thrown the money into like the general stock market, the top stock market funds that everybody else kind of invests in. So a year later, in 2007, she reached a deal with the company Lerner Master Fund, which is controlled by Randy Lerner, who is the owner of the Cleveland Browns football team. I don't know why that's important, but like a lot of the news stories led with the fact that the Cleveland Browns football team owner was involved in this. So Lerner Fund was something called a seed investor. And so to my understanding, this is because if you're the first person to invest in a company or in a hedge fund, it's like a higher risk scenario. You need to have a potential higher reward if everything goes well. So basically, they agreed to be like the first investor in the company, and then eventually they agreed that they'd share some of the future profits when additional investors came on board. So really, Lerner Master Fund, who is an investor, their success depends on the hedge fund getting more investors. Essentially, that's my understanding of what a seed investor is. So this agreement happened on October 2007. The Lerner Fund invested $40 million into Page Capital Management. And as part of the agreement, the Lerner Fund was not allowed to withdraw their money for 3 years. But after 3 years, they could withdraw it without paying a fee. That seems to be the agreement that was struck in October 2007, probably. So about a year later, this takes us to 2008. All of us who were around back then remember 2008 was the bad financial crisis. And at that time, the Lerner Fund took a look at all of their investments kind of across the board because they had a lot more than just Page Capital Management. And as part of looking at all these investments, they had different meetings with the Pages to talk about the funds and what was going on with them. When they had these meetings, they found that no progress was made in investing the money and no progress was made in getting other investors. And after these meetings, they said they were concerned about the Pages' ability to do either of those things successfully. The details of these meetings will be important later, but we'll get back to those. But essentially at these meetings, they said, yeah, we're going to withdraw the money after this 3-year lockup period is done. We're not going to keep it in there. They told them this, first of all, to try to get out of the contract early, which didn't work. But also they said they wanted to give them a heads up since the Lerner Fund was the only real investors in the company. So it would be a really big deal when they took all their money out. They said they were trying to be nice to the Pages by giving them a large heads up. So now we're moving to 2010, which is 3 years later. The 3-year lockup was over and the Lerner Fund said they were going to withdraw. But the Pages said, no, that's not going to be possible because they had raised the gates. So what is a gate? What is a gate in a contract? It seems like that there was something in one of the contracts that said the Lerner Fund couldn't withdraw if they were the only real investor, which they were. So essentially, they want to withdraw because that's what the agreement said. The Pages say, no, are actually over here in our agreement. They said you can't withdraw the full amount if you're the only investor. So, you'll never guess what happens. We're going into court. There are a lot of court filings that came up on the issues of these gates. And it actually seems like a pretty big deal in the law field, the case in general. A lot of different articles citing this case and the outcome as kind of a precedent. That's my understanding of it. And it also created some media buzz, especially in the hedge fund world, also because the Randy Lerner was the owner of the football team. And also because it changed the rules or clarified the rules a little bit about hedge funds. But we're not here to talk about contract law. We're not here to talk about investing. We're here for the drama. Chapter 2. The meetings. So as I mentioned earlier, there were meetings between the Pages and the employees of the Lerner Fund. And this is really where things started to spiral out of control. So in late 2008, they met a total of 4 times. These were information gathering meetings, and they were, quote, not contentious, according to court filings. However, the Lerner Fund employees started to lose confidence in the Pages, specifically Michelle Page's abilities to run the hedge fund. So according to the Lerner Fund Company, this was for a few reasons. First of all, the money that they invested hadn't moved. It was still mostly cash. She hadn't actually made any investments. She just kind of sat on the money. 2, she hadn't gotten any other investors, and she didn't have any good prospects for doing so. 3, she was, quote, unable to articulate in the meetings, unquote, how she was going to move forward, which, if her presentation was anything like the deposition at the Dragon Curve case that we talked about in the previous episode, she doesn't speak or explain things very clearly. Next, her presentation skills, quote unquote, were not up to par. And this included presenting herself as a capable hedge fund manager. The court filings also mention a, quote, delicate but inescapable point, that the Pages didn't dress, look, or behave professionally. The court said that they were more professorial than professional, and academically bright, but not equipped to handle a hedge fund and get investors. So this is a little bit difficult here because it does seem like part of the problem is how they look, which shouldn't be an issue. If someone is capable, it shouldn't matter how they look. But if you don't present yourself as capable and then also you don't look professional, it's worse for you, seemingly from how I'm reading it. So we have some emails directly from the Learner Fund, and they say, on the one hand, she seemed arrogant about her ability to attract and manage a large amount of capital. At the same time, she seemed incredibly lacking in confidence. She struggled to maintain eye contact. She shifted in her chair. She avoided answering questions directly. And another one says, there were certain quirks and mannerisms that sat outside the bounds of normal business interactions, therefore suggesting that if she came anywhere close to doing those types of things in front of potential investors, the immediate answer would be no. They overall summarized the pages as not clear communicators, sloppy dressers, and reluctant to share information. And this is directly from the court summary. Sloppy dressers aside, being not clear communicators and being reluctant to share information are a big problem, especially when $40 million is being discussed. And I do definitely want to be sensitive here. Just because you're not very confident or don't look very confident, or because you don't make eye contact, or if you're just generally kind of weird, and I would consider myself to be all of those things, that doesn't mean that you're not good at your job, or that you can't be good at your job, or that you'd never be able to run a hedge fund. It shouldn't be that way. It's not fair. It's stupid. It is awful that the world works that way, and I hate it. So I just want to say I do really feel for them here in this circumstance, but unfortunately, it gets worse. Chapter 3. Professionalism, the prequel. So we're going to go back to the time before the trial, before the Learner Fund withdraws their money, when they're trying to negotiate a deal so that the Learner Fund won't take the money out. And here, the court records say that the Pages, in emails sent by Christopher Page, sent snide and contentious responses that are inconsistent with the normal way one would communicate with a valued client. So essentially, it seems like the Pages are getting angry, that they want to take their money back, and although the meetings in person were polite and not contentious, the emails sent from the Pages to the Learner Fund were a little bit rude. So, for example, they say that they do not repay old investors with new investors' money. That would make us a Ponzi scheme, not a hedge fund. They also said that if the Learner Fund is so concerned about them getting more investors and raising money, the Learner Fund themselves should invest an additional $60 million, which is kind of funny. Not the way you talk to clients, but it's kind of funny. It's also noted that during one of these meetings, Michelle Page secretly recorded the meeting. That's kind of all they talk about. They don't say whether that's like legal or allowed, but she sure did it. So in the recording, and the reason why the court records talk about the recording is that during these meetings, they don't talk about the gates. These like gates that don't let us take the money out are new. But the interesting part is that, you know, at this meeting, you can hear the Pages agreeing that they want to work out a deal with the Learner Fund. And then after the Learner Fund employees left the meeting, Christopher Page declared that they were now in litigation mode, which is so dramatic and so funny. It's kind of at this point, it feels like rich people screwing over rich people. So it's kind of hilarious to me, like litigation mode. So then, let's get back into 2010, where the Learner Fund files an official notice that they're withdrawing the funds as soon as the 3 years are up. It's not quite the 3 years yet, but they're just giving him a heads up and letting him know. And in return, Christopher Page sends the March 2010 letter, which is very foreboding, but that's what the courts call it. So the email is what we've come to expect from them. The judge characterized it as hostile, which is like not a good look when you want someone to give you $40 million or let you keep their $40 million. It was important to the trial because this was the first time that they mentioned the infamous gates in any conversation. And it is interesting to us because of the threatening and strange tone of the emails. Here's some quotes. We will continue to manage your money throughout the litigation. Similarly, you should remember that you will be responsible for the hedge fund's legal expenses. So, in a very real sense, you will be paying our attorney's fees, as well as your own. We are fully prepared to litigate this matter to the bitter end, because we will continue to manage your money and collect management and incentive fees until this matter is resolved many years hence. The economic reality, therefore, is that you cannot win, because you will spend more litigating than we're fighting over. If this matter is not resolved quickly, we will mitigate our damages by investing the portfolio in high-risk, long-term, illiquid, activist securities in which we specialize. And we will turn the matter over to our attorneys with instructions to spend whatever it takes to defend the company. And again, please remember that you are responsible for the hedge fund's expenses. So, my interpretation, he's saying that they would intentionally weigh them down with litigation and use this invested money to pay for the litigation, to pay for their lawyers, saying that it's going to cost them more than $40 million in the long run to go through all these court cases. My first thought was that, like, it's kind of like a ransom note for the money, which is called extortion. And the Lerner Fund brought that up, but the court ruled that it wasn't. I don't know. They say if you don't let us keep the money, we're gonna get rid of it intentionally. We're gonna waste it. I don't know. He's also saying that they'll intentionally invest the money in places where they're likely to lose it, or in places that it's hard to withdraw from, which is what the Lerner Fund very specifically on multiple occasions asked them not to do, because they knew they were about to take it back. They're essentially saying, hey, we're going to take this money back in like 6 months, invest it somewhere where we can take it out and you can give it back to us. Don't put it in stuff that's hard to get back out. And Randy Lerner, owner of the Cleveland Browns football team, said the statements were, quote, personally threatening and predatory. So then after this letter, it seemed like the pages slowed or stopped communication, and then they wouldn't even send information to them about the funds, like where they were invested and what they did with them. And in May 2010, the pages filed the first part of the lawsuit, and then the Lerner Fund filed a countersuit. However, before the trial could begin, more contentious emails were discovered. But this time, they weren't from the pages. Chapter 4, A Detour into the Gutter. That's what the court records call it, by the way, a detour into the gutter. So, like I said before, by all accounts, these in-person meetings between the Lerner Fund and the pages were professional and they were polite and everything was nice. However, during the discovery phase of the court case, some other emails were discovered that were internal emails between the Lerner Fund employees. And these were not so professional and polite, to say the very least. According to court records, one of the Lerner Fund employees named Robert Balandian sent inappropriate and derogatory emails about Michelle Page's appearance, and they were of an insulting sexual nature. The judge characterized them as immature and degrading, the sort of thing an adolescent bully seeking to ingratiate himself with his male buddies, who are equally lacking in self-awareness and deeply insecure, might send. The judge doesn't repeat the content exactly, but says that they're repulsive and strikingly devoid of wit. So while I don't have the actual emails to read, I feel very confident that these are the origin of the cunt and F-slur accusations that we talked about in the previous episode. So unlike some of the implications in the last episode, these words weren't used by a judge. They weren't used by the courts. They were used by an employee of the Lerner Fund in internal emails. And it looks like the one guy, Balandian, was kind of the worst of the worst, but others did join in to some extent, including Randy Lerner himself, though, quote, not as graphic. That's what the court records say. I can't comment because I don't have all of the emails. So I'd like to pause and say, this is gross and disgusting, hands down. Some people may say, like, oh, it's locker room talk. It's a boys club. This is just how it used to be. But it doesn't matter. It's awful. It's gross. And I'm sure it's incredibly, incredibly hurtful. According to the judge, the pages feature these emails in their own litigation strategy, quote, time and again. In my personal opinion, I can definitely see how the hurt and anger over these emails could lead you to behave inappropriately or lead you to behave in a way that's not in your best interest or like isn't very smart. I do think it is strange to continue to blame the whole court system, in my personal opinion, but who knows? So, back to 2010. The pages talked a lot about these emails during the court case because they said it showed that the Learner Fund just had a personal antipathy to Michelle, and that's why they withdrew the funds, that they just didn't like her, that they didn't like women. The court, the judge, and I kind of disagree with that opinion. Just seeing it between this case and episode 1, they really do not seem equipped to run a business. They just do not seem to know or perhaps care how businesses should be run. But case in point, we come to Chapter 5, The Trial. So once again, there was strange behavior at the trial, and this time, the court memos show that the judges agree with me that this is kind of weird and this is not the norm. So the pages initially did have a lawyer, but then, quote, their relationship deteriorated. I am not sure what that means, but they were technically pro se at this trial too, even though they both have studied law at prestigious institutions. The judge credits them, or maybe is sort of passively aggressively insulting them, but judge says they have resolutely been proactive in this case, utilizing their innate intelligence as well as their legal acumen in defending the complaint. However, the judge also says the trial was marked by a constant stream of interruptions by Michelle Page, some of which were legitimate objections, but most appeared to emanate from a desire to supplement the witness's testimony at inappropriate times. The pages exercised every opportunity to inject sarcasm into their comments, clearly venting their conclusion that the proceeding was a vindictive assault on their integrity. So clearly they behaved at the trial in a very similar way as they did in the Dragon Curve case. Also, another similarity to the other case, to prove that I'm not exaggerating, the judge actually calls out the behavior, saying that Michelle Page's emotions about the case seem to lead her to testify in an exaggerated and hyperbolic terms, often using simple questions from her counsel as a jumping off point to extensive rambling statement. The length of her statements was often not correlated with an ability to set forth a convincing recitation of factual events, with a clear narrative about who did what and said what when. Given these realities and her strong self-interest, Michelle Page's testimony alone is not something I tend to find sufficient in general to prove a contested fact. So one example he gives of hyperbole is that she said, I told them I wanted to invest and I wanted that this was my dream, that I wanted to continue doing these vehicles for, until I was 99. Which is like, okay, little Johnny, what do you want to be when you grow up? A fireman? A teacher?
I want to be a hedge fund manager. I've always dreamed about increasing shareholder value.
Like, what do you mean it's always been your dream to run a hedge fund? Whatever, maybe it is. It also seems like Michelle Page was mistaken about, or perhaps fabricated, a meeting with the Learner Fund, which is not great for their credibility. There was a lot of testimony of whether, there was this meeting where they talked about the gates. It's all about the gates. Michelle said that the meeting did happen. The judge, based on all the other evidence, finds that the meeting probably didn't happen since there was no proof of it. All of the other meetings, they had email exchanges planning them. One of them had a secret recording, and no one mentioned it any at all outside of Michelle Page's testimony. And as the judge says, reticence in written communication is not their trademark, which is quite the understatement. So the judge found that she did lie and say that there was a meeting where they talked about the gates and different terms of the agreement, and that was not true. There was also a rude little remark from the judge. Michelle Page is the only witness who recalls the events she contends transpired, with only weak support from even her loyal husband. That's a little bit passive-aggressive. Also to note, as I mentioned before, it was really only the three of them working there, Michelle Page, Christopher Page, and then Michelle's sister. And she kind of ended up testifying against her and contradicting her. She said that the meeting didn't occur and that she doubted Michelle's story. And also there was some question of why Michelle didn't invest the funds and why they sat in cash. And her sister also contradicted her on that point as well. So that's not great. During another part of the trial, they explained why they didn't give the Learner Fund the information about where the funds were, where the money was, how they had invested it. And they said, quote, Page Capital Management has no books and records addressing key issues like the hedge fund's investment. There's also no explanation of how Page Capital Management conducts its affairs with no records when the hedge fund itself has no employees. Does any of this sound familiar? Is this tingling a little bit of your memory brain cells from the last episode? No books, no records, no employees. Also, it seems like part of the problem, based on what I read, is that there were two different agreements with potentially contradictory wording. And interestingly, in the emails about these two different agreements, the Pages wrote, quote, frankly, I don't know why this distinction matters, so I'd leave it to the lawyers. You are a lawyer! What do you mean you're going to leave it to the lawyers? How do you get a Yale Law School degree and not know what? Clearly the distinction matters. You're in a lawsuit over it. Anyway, the verdict was the Pages had to repay some fees, repay the money, and repay some expenses and fees and stuff related to the lawsuit. So the Pages definitely did not win this case. The Learner Fund won. And as a side note, it said they were also supposed to try to meet and agree on exactly how much money all these fees were. And if not, then both sides were supposed to turn in a little report on what they think the money should be. And the judge gave them a maximum page count of 10 double-space pages, and then in a reply, they can use 5 double-space pages. Is this normal, or is this a special just for the Pages? They're we're not going to read 57 pages of page drama. So anyway, the verdict has been read, the trial is over, but if you think this is the end, you don't know the Pages. Chapter 6. I declare bankruptcy. So, if you're looking at the timeline here, the trial ended in 2011, and now we are going to go a year later to 2012. So after the trial was over, the Pages filed for bankruptcy, and then the Learner Fund filed a complaint with a capital C. And then the Pages sent, quote, a flurry of variously titled responses and, quote, have devoted a considerable amount of effort in filing responsive motions. This to me feels like a judge's sarcasm, perhaps passive-aggressive, but I don't know. They were originally had a lawyer, but then midway through decided to go pro se or partial pro se since they did technically go to law school. So basically, the main point of this trial is the Pages are saying we're declaring bankruptcy. We don't have any money to pay all of these debts. We don't have money to pay the Learner Fund back. And the Learner Fund is saying that the Pages are hiding funds and they're kind of faking their bankruptcy specifically so they don't have to pay the Learner Fund back, but that they do have the money for it. In the end, spoiler alert, it seems like the judge didn't find any evidence that the Pages were hiding money or had transferred money into different accounts or anything. So they did find in favor of the Pages. I assume that means they were allowed to declare bankruptcy and that they did not have to pay all of the fees back to the Learner Fund. But there are a few things to note during this trial. One of them being Christopher Page says that both business and personal expenses were paid from a corporate account and then reconciled at the end of the year, which seems really sketchy. The judge refers to it as, quote, sloppy bookkeeping and a serious compromise of accepted business practices. Where have we heard that before? Another oddity with this case is that After the original trial was over, LMF requested that the pages destroy the crude internal emails that were talking badly about the pages. And the court said that was okay because it seems like the Lerner Fund still had their own copies of the case in case of future litigation. They just wanted the pages to destroy their copies, possibly because they were making such a big deal about it. And the pages did that. But the pages also destroyed their own personal financial records, including records of transfers between the corporate and personal bank accounts. So they defend this by saying that there was so much material in discovery, it wouldn't have been feasible to find and destroy just specific emails or specific documents, that they had to destroy everything. He also says that the Lerner Fund attorneys said that it was okay, that they could destroy the materials, and the Lerner Fund denies that. It seems like the pages did not get in trouble for destroying all this stuff, but don't do that. Like, guys, you're about to declare bankruptcy. Don't destroy your financial records. Like, why would you do that? So after this trial, you'll never guess. There's more court cases. There's more court documents. So now we're moving all the way into 2016. So this is 4 years later. There was yet another trial where the pages actually filed sanctions against the Lerner Fund. And they were basically, the pages were accusing the Lerner Fund of kind of mucking up the proceedings, filing a bunch of frivolous stuff to harass them, that they made the case take longer and cost more money than it should. The judge disagreed, so there were no sanctions that the Lerner Fund had to pay to the pages. And part of this was because the pages actually submitted 4 times as many files as the Lerner Fund, which is important because they said that the Lerner Fund unreasonably multiplied the proceedings and they had submitted 4 times as many files. And this is also nice to know that I'm not crazy for thinking that there were an excessive amount of submissions and documents in these cases. So when they got these no sanction judgment, they immediately appealed. The judge pointed out that the appeal had 16 paragraphs with multiple questions, which I learn now, that's not allowed. You're supposed to state your case. You're not supposed to ask questions and let them decide the case for you, like I read that. It said that in this appeal, they challenged virtually every adverse ruling, and the courts dismissed this appeal in 2018. The pages appealed again. The judge stuck with the previous ruling, and it only took him a paragraph to do that. But the judge continues on, writing a 4-page document because, quote, the tone and contents of the appellant's brief require additional commentary. So first, I'm going to read some excerpts from the pages in their appeal. Michelle Page says, the lower courts unlawfully discriminated against my husband and I, implicitly but unambiguously holding that we are Slurs and cunts with no rights that anyone is bound to respect. And just a side note from me, they use these derogatory terms throughout. Michelle Page also says, for generations, the Third Circuit has turned away African Americans, Latinos, and gays, anyone who did not meet this circuit's limited definition of a person. And jumping in with the judge's response, the judge says, what we have done for generations is give significant leeway to pro se litigants and their filings. Christopher Page says, we respectfully request that the Court of Appeals restore the rule of law, the court's integrity, and the public's confidence by reversing this transparently ludicrous and blatantly bigoted opinion and order, which quite literally held that Slurs and cunts, like my wife and I, are legally obligated to settle, rather than litigate, any and all claims against us because we have no rights that anyone is bound to respect, not even the right to have our briefs read before our appeals are rejected. But I will say in his defense, he did say respectfully. They respectfully request. He said it was respectful. He also calls this court and the members of the bar a cesspool of bigot and the jurists who protect them. Just another side note from me, in my opinion, I'm kind of starting to enjoy all the dramatics. Like, after scrolling through so much legal jargon, these are kind of fun and entertaining. I'm kind of starting to love it. And the judge in this reply seems to be done with their behavior, saying, these filings are striking for their inappropriate tenor, that they cross a line of legal decorum and approach actionable behavior, that they have inappropriate and outlandish commentary, and that it's especially true given the pages are atypical pro se litigants. Both claim law degrees from a prestigious law school and other advanced degrees from respected institutions of higher education. Which, thank you. That has been my sticking point this entire time. Back to the judge's memo. There are also footnotes saying that the page numbers are all messed up in the documents that Michelle and Christopher Page submitted. And that after page 19, it like restarts back at page 1 and all this other stuff, kind of dogging on them, which just feels like he's kicking them when they're down, man. I don't know. This is harsh enough to not pick on them for not being able to do automatic pages in Microsoft Word. The judge also says, we present this additional commentary only to castigate the appellants and to emphasize the importance we place on proper decorum and professionalism. Yeah, and I'm sure they learned their lesson, right? And one final footnote, the last footnote on the page, the judge says that the pages assert, now we all know you won't read this brief. And the judge says, as you see above, we did. Woo! Which I'm getting secondhand embarrassment from this. And even after this, it looks like they appealed again to the Supreme Court in 2019. The Supreme Court denied to hear it. And with that, it seems like we have reached the end of this hedge fund saga. So let's wrap up, shall we? Chapter 7, Loose Ends. So here's what we know. Just to summarize from this case, we have a 3-year investment in a hedge fund that resulted in an 8-year legal battle. In the end, the pages were at fault, but they declared bankruptcy, so it seems like they didn't have to pay it all back and pay all the fees and things. And they got their wrist slapped by the court a good bit along the way, but it does just seem like a wrist slap. It just seemed like a letter back to them and no other consequences of note. There were a few overarching topics between the two cases that I did just want to discuss here, actually. One of them being their law backgrounds and the law degrees from Yale. It was odd to me, and the judge also pointed it out, that it just doesn't match their unprofessional actions and their behavior. So I did just want to look at what their actual credentials are, not to get too much into like who they are specifically, but just like what their degrees are, so that we can understand like, what do you mean you have a Yale law degree and you're screaming in the courtroom? You shouldn't do that. So anyway, Christopher Page has a UVA undergrad, NYU master's, and a Yale law degree. He calls himself a Yale Law School educated moron who won awards for brief writing. Huh. I wonder if he wrote that dramatically in the briefs. He did practice law at some point, but he officially stopped sometime before these trials we just discussed. So he was technically pro se at these trials and the ones we talked about in the previous episode. Michelle Page has degrees from Brown, Yale Law, and Harvard Business School. According to court records, she was also an instructor at Yale Law School and Yale School of Management, and she had clerked for a federal circuit judge. So she knows how the law works. It doesn't look like she'd ever practiced law. She states that her bar status is immaterial, denies any bar membership, and cites the court's, quote, tolerance of bigotry, and says she is disinterested in joining, quote, your corrupt profession. What she's saying here is that all of the courts and the justice system is corrupt, so that's why she doesn't want to be a lawyer. Throughout everything I've seen, this is the first time she's brought this up as a reason why she doesn't practice. I haven't seen this mentioned in any of the court cases. It's also strange because she would have decided not to be a lawyer like way before all of these like emails and allegations and calling came up. I don't know. Just bringing all this up to say, I do want to give them the benefit of the doubt. Like, I really, really do. And it's one thing when it's happening like in a live courtroom, maybe you get over emotional and you have trouble controlling yourself in the moment. But here we're seeing these like multi-page letters and notes to the judge. You should have time before you send that letter to calm down, think about what you're doing, and behave appropriately. So I still don't understand what's going on here, to be totally honest with you. Another interesting thing I happened upon when looking at this case is the question, who is writing the emails? So there is one note from the courts that at one point there is an email sent from Christopher Page's email address, but it seems like the email was actually from Michelle Page. So this is just something to keep in the back of our minds for all the other email communications and stuff that isn't like direct word for word deposition or testimony. We don't actually know who is writing all of these emails, who is writing all of these briefs and letters. It could be either of them. This is something that I was wondering about, but I didn't have any evidence that maybe the emails were not by the right person until now. So not alleging anything, just something to keep in the back of our minds when I say, this person sent an email. Like, it may have been one or the other. One other thing that I want to give them the benefit of the doubt on, it seems like Michelle Page started a company right before the 2008 financial crisis, and then again right before COVID in 2019. And that's really rough. That is really, really bad luck. Very unlucky timing to be starting businesses. I just want to end by putting this case and the money in perspective. There's a lot of stuff going on in this case, and a lot of this is really strange. A lot of this is really disgusting and inappropriate, almost to the point that the money is like an afterthought. So I just want to bring it back here to like what we're actually talking about and what they're actually fighting over. So the Lerner Fund investment was $40 million. And this is only one of many investments that they made into different hedge funds. The Lerner family and the business associated with them, they are not hurting for money. I'm not saying that anyone should be cheated out of money, but I'm just putting it into perspective. They're not going to be living on the street because they lost this $40 million. Also in this hedge fund, pretty much all of the money was from the Lerner Fund, but also Michelle Page invested $40,000 of her own money, which she said included her parents' life savings, which is odd because when you look at the company themselves and the salary, the Lerner Fund paid Michelle Page a management fee of $600,000 annually. And she also got over $100,000 in incentive fees total. So this is just me, man. If somebody paid me $600,000 a year for 3 years and they're like, hey, can I get over this other money back I let you borrow? I just take the salary and go. Like, I just be like, yeah, sure, whatever. I got $500,000 a year for 3 years. If anyone out there wants to pay me $500,000 to sit on their money and not do anything with it, I am more than happy to do so. I will take on that burden and I will give it back to you after 3 years. No gate, no seeds, no gates, no questions asked. And then also I saw in the court documents, the courts were talking about, whether or not they hid money by transferring it between personal and corporate accounts. And the court says, quote, those withdrawals amounted to about $250,000 and $300,000. Nevertheless, at the salary level of Michelle, expenses of that nature are hardly notable. But yet they're declaring bankruptcy? That seems like a lot of money to me. I guess I don't know how about declaring bankruptcy. I think my overall conclusion is like, rich people just live in a totally different world than me. I don't understand it, y'all. That's the end of this case. There are still more cases to see. There is more drama to enjoy. But to end us here, I'm going to leave you with a quote that is allegedly from Abraham Lincoln. He who serves as his own counsel has a fool for a lawyer. I'll catch you next time. Next time on Whack-a-Doodle. Women always lose in your courtroom. Her attempt to withdraw funds would be wrongful and would expose her to potential liability. Who knows? And who cares? Are the only answers that this plaintiff provides in its brief. If they knew we couldn't pay, then anything they gave us was a gift.
The views expressed in this podcast are solely those of the host. The podcast is intended for general information and entertainment purposes only. The content provided is based on publicly available records. The podcast, host, and creators make no accusations, implications, or charges of any crime, wrongdoing, or unethical behavior whatsoever. The host has little to no knowledge of justice system norms, and any opinions stated are for the purposes of humor. Please do not contact anyone mentioned in the podcast.